Hey, what's going on, everybody? This is Phil with Arate Law. I just want to go over this article. I found that was pretty interesting. Talking about the two justices, Thomas and Kavanaugh, Brett Kavanaugh and Clarence Thomas, about the fact that they haven't really done anything regarding the Second Amendment and Second Amendment protections in probably over a decade. So the article goes on to say that the last major Supreme Court cases to decide gun rights and issues were McDonald v. Chicago and D.C. versus Heller, which are very, very influential and they're sort of the bedrock of what is common Second Amendment jurisprudence at this moment right now. So this is where you get McDonald versus Chicago is the one that incorporates the Second Amendment to the states via the 14th Amendment, and D.C. versus Heller is basically that you do have a right to possess a gun for self-defense and in your home. So there's been a lot of other areas, though. The problem is there's a lot of issues. This is something that I wrote about when I was back in law school, specifically the issue of conceal and carry, which hasn't been brought up to the court yet. There's been a lot of cases. The case that I wrote on was Peruta v. the County of San Diego. Was supposed to go up to the Supreme Court, but they didn't take it up. And in that case, Peruta v. County of San Diego was all about whether or not you have the right to carry and conceal a weapon. And this was in California. So not to get too far into it, quote goes on to say, this court would almost certainly review the Constitution of law, requiring citizens to establish a justifiable need before exercising their free speech rights, and it seems highly unlikely that the court would allow a state to enforce a law requiring a woman to provide justifiable need before seeking abortion, Thomas wrote in an opinion joined by Kavanaugh. But today, faced with a petition challenging just such a restriction on the citizens' Second Amendment rights, the court simply looks away. And then Thomas goes on to talk about the backlog of cases. So one issue that we have right now, and I'll get to that in a second, is that all these different courts of appeal all have different standards of what is justifiable, what is good cause, specifically in the terms of carry and conceal or anything like that. So carrying outside the home for self-defense. A lot of these issues are left up to the different circuit courts. So in the Ninth Circuit, we have that Peruta ruling, which is that you do not have the right to carry and conceal. That's not inherent in the Second Amendment. Other circuit courts have different ones, a little bit more laxed. So this issue that the fact that there's all these different sort of conflicting rulings and standards is not, it should not continue to go on. The fact that it's been going on for almost a decade now is something that Thomas is really kind of pointing out. He's saying this is the job of the Supreme Court. If there's all these differing or diverging opinions on what is really the justification to exercise your Second Amendment rights, then this is when the Supreme Court really needs to step in. And goes on to say this is actually in their rule book. I'm going to pull that up right now. So this is actually a Supreme Court rule book. This is Rule 10, Considerations Governing the Review on Certiorari. Now, if you know, certiorari is basically a fancy term for the court, Supreme Court, when what they do is people apply for a writ of certiorari. I mean, does the Supreme Court, want to review a certain case and make a ruling on it? And so these are some considerations that would guide the court in making these determinations of whether they should grant certiorari or not. So it's judicial discretion. Obviously, Supreme Court decides whether or not to take up stuff all the time. The following, although neither controlling nor fully measuring the court's discretion, indicate the character of the reasons the court considers. United States Court of Appeals has entered a decision in conflict with the decision of another United States Court of Appeals on the same important matter, has decided an important federal question in a way that conflicts with a decision by a state court of last resort, or so far depart from the accepted and unusual course of judicial proceedings, or sanction such a departure by a lower court as to call an exercise of this court's supervisory power. And it goes on to say the same thing. You know, they've decided. State Court of United States Court of Appeals has decided an important question on federal law that has not been but should be settled by this court, or has decided an important federal question in a way that conflicts with relevant decisions of this court. So these are some things, and it's laid out right there, and just this one is probably the most applicable right here, subsection A, stating that when you have all these different courts of appeal who have differing opinions on the Second Amendment and sort of what is good cause, what is justifiable, those are issues that need to be decided by the Supreme Court. So this is where Thomas steps in going back to the article, it goes on to Rule 10. The Supreme Court had a chance to issue a major ruling in a Second Amendment case earlier this year, but punted, saying the New York City law in question was changed after the litigation was initiated, making the case more moot. Moot basically means when a case really has no point anymore. So if you bring a case and it's been resolved already, the case is moot. There's no reason to litigate it anymore. And this is probably Thomas closing with this parting shot at his fellow justices. Rather than prolonging our decade-long failure to protect the Second Amendment, I would grant this petition. And what he's talking about is this New Jersey petition. Near total prohibition on carrying a firearm in public violates the Second Amendment right to bear arms made applicable by the states to the 14th Amendment, such as McDonald versus City of Chicago, which we just talked about. This case gives us the opportunity to provide guidance on the proper approach for evaluating Second Amendment claims, acknowledge the Second Amendment protects the right to carry in public, and resolve a square circuit split on the constitutionality of justifiable need of restrictions on that right. So Thomas is really, he's one of the, I would say, after Scalia passed away, he had to kind of take up the mantle for Second Amendment rights. And he's talked about Second Amendment rights. And I believe he actually made a comment about the Peruta v. County of San Diego case and how, again, the Supreme Court really hasn't taken up that many Second Amendment cases. And then it's sort of a crime that they haven't taken up as many as they should. I mean, it is part of the Bill of Rights. It's part of the Constitution. We do have all these conflicting Court of Appeal, lower court rulings. One's more relaxed, one's more strict. They're all over the place. It's really the Supreme Court. They should step up and say, okay, this is the standard from here on out. But they haven't done so. And I don't know why they haven't done so. Maybe it's because they don't think, it's hard to decide. They don't really tell you, and the Supreme Court really doesn't explain why. A lot of times what goes on in their chambers is really just only known to them. So the fact that they really don't take a lot of these things up is kind of a mystery. But I think you're going to start seeing maybe Brett Kavanaugh and Thomas and maybe some of the other more conservatives like Gorsuch. They might start to look at these Second Amendment cases more because there is this split. And there does need to be some resolution, especially here in the Ninth Circuit, which went all over the place. From their first ruling was you do have a right to carry and conceal. Then they changed it because at the time Attorney General Kamala Harris stepped in, asked for it to be heard en banc. Then once it was heard en banc, then they overruled it and said you do not have the right to carry and conceal. And then went up to the Supreme Court and they didn't take it up. And that's sort of where we're stuck at right now, is this Ninth Circuit decision that you really don't have the right to carry and conceal. So just something interesting to think about, since there hasn't been any Supreme Court Second Amendment case in a long time. And it looks like Thomas and Kavanaugh now are getting a little frustrated with it. And they're starting to say, look, we're the Supreme Court. We have to do these things. We do these things because we have to resolve this. We're the final arbiter. We're the final say on these issues. And if there's a conflict of these issues, it's really up to us as the Supreme Court to resolve that. And leaving it all murky and murky and confusing from one circuit court to the other, it's really not beneficial to people within the United States. So with that, I just wanted to touch upon that because I thought it was an interesting article. I think it's interesting that Thomas and Kavanaugh are now starting to get upset about what's going on. And maybe they'll force their hand and maybe we'll start to see a Second Amendment case. Because I know there's probably dozens of them trying to get to the Supreme Court. And there's, so Peruta v. County of San Diego is just one of them. And in this case, it was a New Jersey case. So there's dozens of them that are probably just trying to make it up to the Supreme Court, and they haven't done so yet. So with that, just wanted to talk a little bit about that. Maybe we'll keep your eyes peeled to see if the Supreme Court changes their tactics and maybe take up a Second Amendment case in their next session. And we'll see. Fingers crossed, and we can get some more guidance on that and get some better uniformity when it comes to what is good cause, justifiable, carry and conceal, all that sort of thing. So with that, thanks again.